Article 129. Search warrant maliciously obtained in abuse in the service of those legally obtained, in addition to the liability attaching to the offender for the commission of any other offense. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period and a fine not exceeding 1,000 pesos shall be imposed upon any public officer or employee who shall procure a search warrant without just cause or having legally procured the same shall exceed his authority or use unnecessary severity in executing the same. Number 1. What are the punishable acts in connection with search warrant? Acts punishable in connection with the search warrants. Number 1. By procuring a search warrant without just cause sa pamamagitan ng pagkuha ng search warrant na walang tapat na dahilan. Number 2, by exceeding his authority or by using unnecessary severity in executing a search warrant sa pamamagitan ng paggamit ng pagmalabis ng kanyang kapangyarihan o sa pamamagitan ng paggamit ng hindi kinakailangang karahasan sa pagpapatupad ng search warrant na legal ang pagkuha. Number 2, what are the elements of procuring a search warrant without just cause? Elements of procuring a search warrant without just cause. A. That the offender is a public officer or employee, na ang may sala ay isang opisyal publiko o empleyado. B. That he procures a search warrant, na kumuha siya ng search warrant. C. That there is no just cause, na walang tapat na dahilan. Number 3. What is a search warrant? A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge, and directed to a peace officer commanding him to search for personal property described therein and bring it before the court. Section 1, Rule 126, Revised Rule of Criminal Procedure. Ang search warrant ay isang utos na sulat na ilibas ng pangalan ng mga tao ng Pilipinas, permado ng huwes at inuutos ng isang alagad ng batas. Inatasan siyang siyasatin ang personal na pag-aari na inilarawan doon at dalhin ito sa korte. Section 1, Rule 126, Revised Rules of Criminal Procedure. Number 4. What are the personal properties to be seized? A search warrant may be issued for the search or seizure of the following personal property. Ang isang search warrant ay pwedeng ilabas para magsiyasat at pagkuha ng mga sumusunod na pag-aari. A. Subject of the offense, paksa o ginamit sa isang krimen. B. Stolen or embezzled and other proceeds or fruits of the offense. Ninakaw o kinamkam ng ibang galing o mga bunga ng krimen. C. Use or intended to be used as the means of committing an offense. Section 3, Rule 126, Revised Rules of Criminal Procedure. Ginamit o iniukol para gamitin bilang paraan ng pagsasagawa ng krimen ayon sa Section 3, Rule 126 of Revised Rule of Criminal Procedure. Number 5. What are the requisites of issuing a search warrant? A search warrant shall not issue except upon probable cause in connection with one specific offense to be determined personally by a judge, after examination under the oath of affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the things to be seized, which may be anywhere in the Philippines according to Section 4, Rule 126, Revised Rules of Criminal Procedures. Ang isang search warrant ay hindi maipapalabas pera na kung may maaring dahilan na konektado sa isang tiyak na krimen na ipasyang personal ng huwes pagkatapos ng pagkakasuri sa ilalim pang panunumpa ng nagreklamo at ang kanyang mga testigo na pwede niyang iharap at partikular na ilarawan ang lugar na sisiyasatin at ang mga bagay na kukunin na pwede saan man sa Pilipinas. Section 4, Rule 126, Revised Rules of Criminal Procedure. Number 6. How is the examination of the complainant being done? The judge must, before issuing the warrant, personally examine in the form of searching question in answer, and writing and under oath the complainant and the witnesses he may produce on facts personally known to them and attached to the record their sworn statement together with any affidavit submitted. Section 5, Rule 126, Revised Rules of Criminal Procedure. Ang huwes dapat, bago ipalabas ang warrant, ay personal na masuri sa pamamagitan ng mga mapanuring tanong at sagot, sa sulat at sa ilalim ng panunumpa, ang nagreklamo at ang kanyang mga testigo na pwede niyang iharap sa mga katotohanang alam nilang personal at ikabit sa talaan ang kanilang pinanumpaang salaysay kasabay ng mga affidavit na binigay. Section 5, Rule 126, Revised Rules of Criminal Procedure. Number 7. What is the concept of right to break door or window to effect search? The officer is refused admittance to the place of directed search after giving notice of his purpose, and authority may break open any outer or inner door or window of a house or any part of the house or anything therein to execute the warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. Section 7, Rule 126, Revised Rules of Criminal Procedure. Ang opisyalis kung tinanggihang makapasok sa lugar na inatas siya sa atin pagkatapos magbigay ng abiso sa kanyang pakay at otoridad ay maaring sumira upang buksan ang kahit anong panlabas o panloob, pintuan o bintana ng bahay o alinman sa parte ng bahay o kahit anong nasa loob nito para maisagawa ang warrant o mapalaya ang sarili o alinmang taong legal na tumutulong sa kanya na illegal sa loob. Section 7, Rule 126, Revised Rule of Criminal Procedure. Number 8. How many witnesses should be present during the search? The search of the house, room, or premises to be made in the presence of 2 witnesses. Ang pagsisiyasat ng bahay, kwarto o looban ay kinakailangang gawin sa presensya ng 2 testigo. No search of a house, room, or any other premises shall be made except in the presence of the lawful occupant thereof or any member of his family or in the absence of the latter, and the presence of 2 witnesses of sufficient age and discretion residing in the same locality. Section 8, Rule 126, Revised Rule of the Criminal Procedure. Walang pagsisiyasat ng isang bahay, kwarto o kahit anong looban ang gawin pera na lang kung ang nasa harapan ng legal na nakatira doon o kahit anong sakop ng kanyang pamilya o kung wala ang huli sa harap ng 2 testigo na may sapat na gulang at pagpapasya na nakatira sa parehong lugar. Section 8, Rule 126, Revised Rule of Criminal Procedure. Number 9. What is the validity of a search warrant? A search warrant shall be valid for 10 days from its date. Thereafter, it shall be void. Section 10, Rule 126, Revised Rule of Criminal Procedure. Ang search warrant ay mabisa hanggang 10 araw mula ito'y nailabas. Pagkatapos nito ay wala nang itong bisa. Section 10, Rule 126, Revised Rules of the Criminal Procedure. Number 10. What is the receipt of the property being seized? The officer seizing the property under the warrant must give a detained receipt for the same to the lawful occupant of the premises in whose presence the search and seizure were made, or in the absence of such occupant, must in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality, leave a receipt in the place in which he found the seized property. Section 11, Rule 126, Revised Rule of Criminal Procedure. Ang opisyal na kumuha ng pag-aari sa pamamagitan ng warrant ay dapat magbigay ng detalyadong resibo para sa nakuhang pag-aari na legal na nakatira sa bahay o kung saan sa harapan niya ang pagsisiyasat at pagkuha ng ginawa, o kung walang nakatira dapat sa harapan ng hindi kukulangin sa 2 testigo na may sapat na gulang at pagpapasya na nakatira sa parehong lugar. Iniwan ang resibo sa lugar kung saan nakita niya ang kinuhang pag-aari. Section 11, Rule 126, Revised Rule of Criminal Procedure.